Back to mention item number 2, Lordship. The adjournment slip has been circulated, Lordship. Lordship, senior is not well, Lordship. He is undergone surgery, Lordship. That's why.
Who is for the other side?
Yeah, APC was there, Lordship. We have taken consent, Lordship.
Okay. You are Mr.
A Mena, Lordship.
The prayer of Mr. A. Mena with the consent of the other side. The matter is adjourned for the day. Let the matter be listed on.
Any day after 2 weeks, Lordship.
Let the matter be fixed after 2 weeks.
Obliged.
May I please, Your Lordship? Your Lordship, with respect to item 7,
Hmm.
we have filed our affidavit in opposition on the 27th. However, it doesn't appear to be on record. So Lordship can fix another date for the same. We have served a copy as well.
You are appearing for the
BTC,
petitioner.
Lordship.
Huh?
BTC.
BTC.
Lordship.
I am for the petitioner here.
You are for the petitioner. You have received the copy?
Yes, madam, I have received. They fix on 4th of February, madam.
You are Mr.
And Sharma, Lordship.
Heard Mr. N.R. Sharma, the learned counsel, appearing for the BTC. BTC, full stop. He submits that an affidavit in opposition in the instant case has already been filed. However, the same is not on record. Mr. A. Kaklari.
Eboro.
Sorry, the learned counsel appears for the petition. Let the matter be fixed. When do you want it?
4th,
4th?
4th, yes. Day after tomorrow. Or 6th, madam.
Okay, let the matter be fixed on 4th.
Obliged.
Obliged, Lordship.
May it please your lordship. Lordship, with regards to item number 3 of the daily list,
Yes,
lordship, I beg an adjournment in this matter, your lordship. My senior Mr. K. N. Chaudhary is out of station, your lordship.
you are Mr.
T. Kashyap, your lordship, for the
Mr.
petition.
A. Kashyap, the learned counsel, appearing on behalf of Mr. K. N. Chaudhary, the senior counsel, appearing for the petitioner, submits that Mr. K. N. Chaudhary is out of station. Therefore, he prays for some time. Let the matter be fixed when?
Lordship, after 2 weeks.
Let the matter be fixed after 2 weeks.
Much obliged.
Item 11, report of police item 1. Wait.
Lordship, this is second bail application, the rejection of the earlier. In 91 days, now 179 days in custody. Lordship, in this bail application, we have.
Charge sheet file,
Yes, Lordship, we have also.
charge sheet file,
entered-
LCR has come probably.
My lord, here, what has happened last occasion, service was taken, they have, my lord.
Mr.
Technical
We have engaged,
POXO order, this is, my lord.
we have appointed somebody.
That order I have not seen, my lord. As per the office note dated 22/1 service, they have taken the service, my lord. Whether received or not, I don't know. my lord.
Yes. Lordship may appoint, in the earlier matter, Lordship had appointed.
In the AB, we have appointed someone.
Yes, yes.
Bail totally zero. So we will appoint, Mr. Fukon only, because the earlier ABB application, we have appointed Mr. Fukon as amicus. So in the matter, in this matter also, we'll appoint Mr. Fukon as amicus.
Give a copy urgently, Lordship, I fix something.
Yes, yes.
Give a copy urgently.
Okay, in the bail matter event, heard Mr. B.P. Bora, the learned counsel appearing for the accused applicant. Also heard Mr.
RR Kaushik.
R.R. Kaushik, the learned APP for the state, representing respondent number 1. Seeing the office note dated 21/1/2026, which reveals that notice to respondent number 2 has already been issued. How the same is yet, how the AD card is yet to be received. Notice was issued to respondent number 2. Notice was issued to respondent number 2 on 21/1/2026. Also, looking to the urgency of the matter, this court is of the considered opinion that an amicus should be appointed to represent respondent number 2 in the instant case. Therefore, Mr. Aruna Phukan, the learned counsel, is appointed to assist the court as amicus curiae in the instant case representing respondent number 2. Let the matter be fixed. Let the matter be fixed on next week sometime.
Yes, Sachin.
Let the matter be fixed on tenth of February.
Deeply.
10th of February, this one. Heard Mr. The other one, other order. Heard Mr. BP Vora, the learned counsel for the learned counsel for the accused applicant. Also heard Mr. So-and-so, the learned APP for the state. None appeared for respondent number 2. Let this matter be listed along with bail application number 65 of 2026 on 10th of February. Yes.
The termination matter which your lordship had already heard, and in fact lordship had almost dictated the order, but some queries arose.
Ah.
With the terms and conditions of the contract agreement which was entered between the parties. Now, I have quoted the relevant provisions in my writ petition.
That you have quoted, but like the one they have given was different.
It did not match with that, my lord.
Yeah.
Not found, my lord, that terms of contract of the petitioner, my lord, but I have received the old one. The petitioner may sign the old.
The earlier one only or the different one?
It is
I have-
slight difference.
My
my lord.
client could hand over a copy of that.
That the one that you have quoted.
Yes, it matches, my lord. Mine one is correct. 8 and 9 is relevant.
One has been followed from 2016, 15 and 16, 15 or 16. As the petitioner.
But this one is same, I think.
This is the old one which she has handed over to them. It matches with the,
It matches with yours.
yes,
Matches with what? That means the quotation you have given in the petition. That is same.
because he had noted it down from the original contract agreement. He was given a permission.
Okay,
to-
can you rephrase a bit? I mean, can you
Yes,
rephrase a
yes.
bit?
Lordship, may kindly come to page 23,
Page 23,
annexure 3. This is the so-called notice that was issued.
page 23.
Right.
Yes, yes.
Says, my lord, whereas it has been reported that you are apparently not maintaining the books of accounts up properly at your place of duty, which is not at all accepted under NHM in mission mode, you are hereby asked to show cause. Why disciplinary action, my lord? This word is most relevant. Why disciplinary action? As per clause 9, that clause has been wrongly quoted here in clause 9 of the terms and conditions. Terms of contract should not be initiated against you for your apparent indiscipline and negligence towards duty. Worship will also mark the
Now read if you read clause 9.
clause. Clause. Just a Clause 9, my lord. Either of the parties hereto have the right to terminate this agreement without assigning any reason, provided that a written notice of 1 month is given to the other party. Both the parties may, in lieu of the written notice, give the other party a sum equivalent to the amount of his salary for 1 month or shorter notice than 1 month, with a sum equivalent to the amount of his pay for the period of which such notice falls short of 1 month. So apparently, my lord, they have not taken recourse to this clause, my lord. They have taken recourse to clause 8. And if that be so, my lord, without a departmental proceeding, they could not have terminated my service, my lord. That is the case of the petitioner, my lord. And in fact, my lord, this honorable court, my lord, when the matter was moved initially, was satisfied with the arguments advanced by me, my lord, and this honorable court was pleased to pass an interim order, my lord, staying the operation of the termination order, and he is still continuing in service.
So it's, according to you, it's punitive.
Punitive and stigmatic, my lord. And it's admitted in the affidavit in opposition itself. They clearly say that they have initiated disciplinary action against me. If that be so, before that, my lord, the termination order, if I may place, my lord, page 30.
Page 30.
Page 30. Clearly, it states, my lord.
Yes.
Seen and perused the reply received from your end in response to the so-called notice referred above. You were issued so-called notice for not maintaining the books of accounts properly at your place of duty. The reply received from your end has not been found satisfactory, my lord. Such indiscipline and negligence towards duty are not at all acceptable under NHM in mission. Negligence and indiscipline. And in the affidavit in opposition which they have filed, in paragraph 5 and 6, they have clearly stated, my lord, they have taken disciplinary action. my lord.
Where are 5 and 6?
5 and 6. Page 2 of the affidavit in opposition.
And what is this order,
Which one?
31, page 31?
Page 31.
Similar kind of case?
Yes, my lord. By relying on this order, my lord, I got the interim protection, my lord, from this honorable court. And there is no allegation of misappropriation against the petitioner. There is no misappropriation, my lord. It's just a.
No, they are not saying about misappropriation.
Nothing.
They are saying about you are being negligent.
Negligence.
You are being negligent and not keeping the books of account as per
Properly.
as
That
per
is
the
not
norms.
The case, my lord.
As per the norms.
As per the norms, my lord.
Hmm.
That is the case. My lord, he was just appointed as the accounts officer at that point of time, and he was just following the procedure adopted.
Yeah, he
by
was a
him.
new guy. He was a new person appointed, so there may be here and there little bit of, differences with the norms that has been set down. For that, you are terminating him.
As per clause 8 of the, my lord, terms of.
The clause 8, what does clause 8 say?
that,
Disciplinary action.
the
No, you have not taken any discipline action. You have only given a so cause notice. And you are saying that it is not, you are not satisfactory and you are terminating him. Terminating somebody with a stigmatic and punitive manner. That, can it be done like that? If you say it can be done like that, then show me a case law or judicial pronouncement from our High Court or Supreme Court saying this kind of contracts you can do it. In fact, day before yesterday, Supreme Court has come very heavily, I mean, on this kind of contractual employees. I mean, this is not, this is contractual employee, right?
Contract.
Contractual employees, you are, I mean, you are engaging him, then like let him work for some time, then on your whims and fancies, you try to terminate him.
Now,
Yes.
petitioner is at a much more advantageous position because the government of Assam has already adopted the policy decision to continue them till 60 years of age. That policy also I have, my lord, if lordship.
It was annexed here.
No, it was not, it has come in subsequently, my lord.
No, to keep whom? Contractual employees.
Yes, contractual. This one. So he can continue till 60.
Provided he's he's on the job.
He,
If he's terminated, how will he continue?
by the grace of this honorable court, he is still continuing, my lord.
How many years you have completed?
I joined in, my lord, initially I joined in
You joined in a different post, right?
different post. Thereafter, I was, my lord, sort of promotion, my lord, upgraded. In 2008, my lord, I joined, my lord, 2008.
2008. 2008 as, in 2008 as what? Not as an accounts officer.
PHC accountant come assistant block program manager.
Okay.
PHC accountant come assistant block program manager. At Guimara SD subdivision in the Kamrup district.
Yes, what do you have to say?
My lord, as per clause 8, he may be terminated for his non-performance, my lord. So, as
But
per
you have not,
clause-
but you have not terminated him under clause 8.
as per law. As per
Clause 8 is
9,
a, clause 8,
termination or notice on was issued, my lord. That was stayed by this honorable court.
correct. The clause 8 is a different altogether. Clause 8 is, I mean,
Strict of disciplinary action.
you can terminate him at your pleasure, provided you give him something. Can't do that. So we'll conclude it. We'll pass the order. Heard Mr. B. Sharma, the learned counsel appearing for the petitioner. Also heard MS A. Bora, the learned standing counsel for NRHM. Hearing concluded. Judgment reserved.
Much.
Mr. Plummer. Yes.
This is against an order of penalty passed by the respondent deputy CA. What had occasioned this?
Hmm?
May I please, your lordship?
Yes?
Your lordship, we have not communicated with the department, but instruction, we have not received any instruction. Your Honor, may grant 2 weeks time, we will file an affidavit.
The matter pending since 2024. The facts and lordship in the preliminary investigation, preliminary inquiry report based upon a purported confession by me.
Now, why haven't you filed your affidavit till now?
Your Honor, we have not received any instructions.
No, not received means what? That initial order was passed on 28/6/2024. Yes, what is the case?
The case is lordship. A preliminary inquiry report was filed, submitted against me. Lordship, wherein
What was the allegation?
Lordship, allegation was that while serving in the APDCL, we had taken some amount from the candidates to include their names in the compassionate appointment scheme, Lordship. For their
Okay, who
appointment.
are you otherwise?
Lordship, I am a bill clerk cum meter reader.
Hmm?
Bill clerk cum meter reader, Lordship.
Bill clerk,
Bill clerk.
yes.
Now, Lordship, at the preliminaries, when the preliminary inquiry was conducted, Lordship, I submitted my written statement denying the same.
Hmm.
Subsequently, Lordship, on 17/9/2020, on the last date, it's my categorical stand that I was pressurized by the inquiry officer to confess to the same. I submitted purported confession on 17/9, and on the same day, a 304-page report was submitted on the very same. Subsequently, Lordship, show cause notice was issued to me. We replied. Departmental proceedings were drawn up in the regular inquiry. The inquiry officer came to a finding that the charges were not proved because the witnesses who purportedly had made submissions before the preliminary inquiry that we had taken,
They were not examined.
they were examined. They stated that we were forced to do this. I did not ask for any money, and Lordship, that was done as was dictated to them, and they do not know the contents of the statements made by them before the preliminary inquiry proceedings were dropped. We were exonerated. Subsequently, Lordship, disagreement note was issued solely based on the confession, stating that you have confessed before at the stage of preliminary inquiry. Therefore, stoppage of 1 increment with cumulative effect.
You have come against that.
We have come against that.
So let them file an affidavit. You are already in the, with some protection, right?
Lordship, then increment.
So how much time will it take?
Your Honor, 2 weeks.
Hmm?
2 weeks, ma'am.
Lordship, may I please that it may be the last chance because his promotions are also held up on this point. I understand, Lordship, if it goes in his favor, he will get it, but
Heard, Mr.
H.
H. Chakraborty. The learned counsel appearing for the petitioner, your name?
C. Paul.
Huh?
C. Paul.
For the petitioner, and also heard Mr. C. Paul, the learned, your standing counsel?
No, on behalf of KP Bhatt.
Learned counsel appearing on behalf of Mr. KP Pathak, learned standing counsel, APDCL. Mr. Paul submits that instructions in the instant case is yet to be received. Yet to be received for filing an affidavit. Therefore, he prays 2 weeks' time to get the instructions and file an affidavit. The learned counsel appearing for the petitioner opposed to such prayer, stating that the matter has already been stating that the interim order was passed long time back on 28/6/2024. No, not interim notice. Notice was issued on 21, and therefore no such time should be granted. However, considering the facts of the case, this court is of the opinion that 2 weeks' time should be granted to the APDCL to file their affidavit in opposition. Place the matter after 2 weeks. After 2 weeks, it file it positively.
The interim may be continued.
Interim orders so passed earlier shall continue till the next statement.
Right.
May I please your lordship? Lordship, Mr. S.S. Roy had to leave the court for some personal difficulties, lordship. Lordship, may I pass over the matter for the day?
SS Roy is appearing for whom?
For the respondents, Your Lordship.
Respondent?
Respondents, all the respondents.
All the respondents.
Just some urgency, sir. Shortage can be given.
Heard Mr. M. Mahmood, the learned counsel appearing for the petitioner. Also heard
M. Burman.
M. Burman.
On
M.
behalf of
Burman
SS
on
Roy.
behalf of Mr. SS Roy, the learned CGC for the respondents. Ms. Burman submits that SS Roy has to leave the court for some, has to leave the court for some personal work. So personal work, therefore she prays adjournment of the matter. Full stop, prayer is allowed, let the matter be listed. When do you want it? Let the matter be listed on 6th, it will be difficult. On 12th February. 12th or 13th February.
Let it be 11, madam, 12 or 11.
11, it will be little bit difficult for this court. There are some matters in division
Then it
bench.
will be 16.
16th, okay, 16th.
Item 6.
Lordship, in this matter, this is newly entrusted to me, I'd like to file an wakalatnama.
Okay.
Was the earlier counsel, Mr. Majumdar was the earlier counsel. So I'll just seek 2 weeks time.
In this matter, they are yet to file the rejoinder. So
Huh?
they are yet to file the rejoinder.
He is newly engaged.
Yes, sir. That's why my lordship may grant them 3 to 4 weeks time so that they come up with the rejoinder.
My-
Would you open it? Mr. Gogoi will not take 3-4 weeks. How much time?
Let it be 3 weeks, madam.
3 weeks, okay. Heard Mr. D. Gogoi, the learned counsel appearing for the petitioner. Also heard Mr. M.R. Adhikari, the learned CGC. For all respondents, for all the respondents, the respondent. Mr. Gogoi submits that he has received instructions from his client to appear in this matter. However, wakalatnama in the instant case is yet to be filed. Therefore, he prays for some accommodation. It is also submitted that affidavit in reply in the instant case has to be filed. Therefore, he seeks 3 weeks time for filing the affidavit in reply. Full stop. Prayer is allowed. Let the matter be fixed after 3 weeks.
Right.
There's an interim operation.
Interim order so passed earlier shall continue till the next date of listing.
Fixed date will be given.
After 3 weeks,
Obliged.
25th of March or February. February, you'll get 3 weeks, yes.
Obliged.
But all the petitioners are serving as
Hmm?
grade 3 and grade 4 post
Hmm.
in different high school, my secondary school.
Who is appearing for the state?
And their service has been provincialized against fixed pay. And they are claiming they are paying for minimum pay.
No one is there for the. Mr. Sisti is not there?
Court has passed, my lord, honorable court has passed similar orders on the same issue.
Hmm?
Same issue, this honorable court has passed.
This is a covered matter.
Yes,
How it is covered? You tell me your facts.
my lord, our service has been
But
provincialized.
nobody is there from their side.
Yes, that is.
Can we pass the order without them? Is anybody there? Yes, yes,
Page
what?
28, my lord, page
Hmm.
28 onwards,
Hmm.
out of 30 petitioners, we have annexed few petitioners appointment order. Because initially we were appointed by the SMC, School Managing Committee, and our service has been provincialized
Hmm.
as either as junior assistant or grade 4, page 28.
Hmm.
As per the Assam Education Provincialization Service Non-Teaching Staff of the Bhansar Educational Institution Act 2018. And since 2011, 2021, we have been serving as such, my lord, on fixed pay.
From 2011, you have been working.
Prior to that, initially we were appointed 90,000 like that, but our service has been provincialized with effect from 4th January 2021, because that act has come in the year 2018.
Okay, after the act on, in 2021, your service is provincialized.
We have been receiving.
So
fixed
what is
pay.
your grievance exactly?
Well, we have been receiving fixed pay, page 29,
Huh.
serial number 8 and 9.
So you are receiving fixed pay, but,
Only 8,000 and 10,600.
you want a regular payment?
Yes, ma'am, regular.
Regular,
scale.
regular payment, I mean, as paid to the other,
Yes, madam.
grade 4,
Yes, ma'am, grade 4 and grade 3.
grade
Junior
4 and grade 3.
Yes. And squarely this two judgment
Just give it.
on the same issues. Because similar matter division bench held that the teachers, because the Sonabul code has directed the authorities to consider for regular time scale in respect of tutors, but same judgment will be covered in respect of non-teaching staff also. In the petition 6812, paragraph 6 and 7.
Paragraph 6 and 7.
In writ petition number 6812, Honorable Justice.
Huh.
Paragraph 3.14, same. Ma'am.
Yes, madam, somebody is there. You are there for,
One is higher, one is elementary, second.
you are from elementary, higher. Elementary is not there. You are also elementary or what? Or higher, okay. Elementary, secondary and higher.
That's sometime in a right.
Hmm? You call somebody, if it's covered this thing, then we can close this. Pass it off time being. You see anybody is there, Mr. Sisti or somebody?
Middle 9 and 10.
McDonald.
Yes.
My lord, petitioner before your lordship was lastly serving as chief manager of Arunachal State Bank branch in Kachar district, my lord. He was
What,
suspended-
which bank?
SBI, my lord.
SBI, okay.
He was suspended, my lord, on 9/5/2025.
Hmm.
It is at page 161, my lord.
Pays?
Page 161. An operative part, my lord, page 162, my lord, the third paragraph. The legal portion, how he was placed under suspension.
162, third paragraph.
Third paragraph, my lord.
During your,
In view of the above,
ah,
it has been decided not to allow you to continue in active service of the bank. Accordingly, you are placed under suspension with immediate effect. In terms of the SBI office service rules, a copy of the order dated so and so is enclosed here. So, my lord, thereafter, my lord, in my lord, 3 months, this suspension order
was not reviewed.
reviewed, and my lord, not charge sheet was also submitted.
Hmm.
Admittedly, it is as per their affidavit in opposition also. my lord.
Where affidavit in opposition?
My lord,
This is the only ground, your ground.
Yes, man.
Why such a bulky file?
Yes, man.
Huh?
Earlier, my lord, my learned friend filed.
Page?
In their affidavit in opposition, lordship, kindly will look page, paragraph 13, my lord, page,
You tell me the page.
268, my lord,
268.
268, my lord.
268, paragraph
13, my lord, it is date.
268 is something else.
Paragraph
268 is something else.
258, my lord, the running, my lord, page.
Wait, the pages are a little bit. Okay, okay, there is another 268. Maybe. No. Two 68 is not affidavit.
But they are, in the writ petition, my lord, the last page is 261. Thereafter, they are affidavit in opposition. It is submitted by Sri Sokat Datta.
Sokat Datta, no?
Yes, ma'am.
No, that is at page 306. Which para is it?
Well, the mentioned it is para 13, just I am showing on a date of suspension, para 13. Now, he was suspended, my lord, on 9/5/2025. Then, my lord, paragraph, I beg to refer paragraph 16, my lord. According to them, my lord, the charge was forwarded on 9/5/2025, my lord, paragraph 16. Then, my lord, according to them, my lord, suspension.
Para 16 says what? 19/9, 6/9, 9/5/9.
5/9, my lord, according to them, my lord, charge was framed. This is also after 3 months, my lord. And paragraph then 21, suspension was reviewed, my lord, on 13/10/2025. This is also after 3 months.
So suspension was reviewed.
Reviewed, it is, my lord, though it is not communicated to the petitioner, my lord, according to them, my lord, but it is also after 3 months. In this regard, my lord, I beg to, my lord, submit, my lord, to judgment, my lord. Or
So this is only your ground, right?
this is
But the review was not done within 3 months.
review and charge paper. WPC, my lord, 1074/2023, my lord, it is regarding, my lord, suspension was not reviewed in time. It is fact of the case, my lord, paragraph 3. He was suspended, my lord, on 1/11/2022. And paragraph 20, my lord, it was provided that, my lord, it is the admitted position in the instant case that a review of the order or suspension was done only on 3/2/2023. It is clear that the said review was not done within mandatory period of 90 days and required under the law. The Honorable Supreme Court in the case of so has clearly laid down that review done beyond a period of 90 days would not serve the purpose of law and would have no consequence. In the instant case, it is also admitted.
Okay, what is the stand?
Your Lordship, here, Your Lordship, the petitioners, they were involved in certain irregularities. while
And that is fine. I mean, only thing is that here factual stuff may not be required. The only thing is that law point.
that-
I mean, that's a settled law.
Lordship,
What,
but the
what do you
review
have
has
to
be
say on
done.
that? Huh?
In this instant case, Your Lordship,
Hmm.
the charge sheet has already been submitted and disciplinary proceeding is ongoing, Your Lordship.
No, that happened after the mandatory period of 3 months, which
Lordship.
has been laid down by the Supreme Court in many cases.
Lordship.
In our High Court has also held. That after 3 months, you can't do that.
Because they are protected, the SBI rules, Your Lordship, SBI officers rules.
Hmm.
We have also quoted in paragraph, in page number 276
Hmm.
of our affidavit.
Page
276.
SBI rules, are they different?
Your
No,
Lordship,
it's same manner.
No,
I have an next man rule.
no, why they are protected, Your Lordship?
Hmm.
Because their suspension cannot be revoked at this stage is there, because the transaction and everything is done digitally, Your Lordship. And if they are reinstated back to service, Your Lordship,
Hmm.
if their suspension is revoked,
Hmm.
there's every chance of tampering and hampering because they have access to the digital system of the bank.
Hmm.
In that case, Your Lordship, there's a provision, yes, as a rule, as
Which page,
page number 276 of our affidavit in opposition, Your
276.
Lordship.
It will be a different page. I don't know why the pages are different.
376.
276.
It would be 370.
276 is something else.
It would maybe one of 370.
376, probably there is some page initial.
100.
Paragraph number 25, Lordship.
Wait. Not 276. You should take those, continuous paginations from this court's copy.
Lordship.
Then only you can refer it. I mean, otherwise now you are referring to a different page. Here these are all different.
Instead of
Now I
200, you have referred 100, 300.
Affidavit in opposition is in paragraph 25, if your Lordship go by the paragraph.
yes.
Paragraph 25, Your Lordship. Next page, Your Lordship. 376 probably.
Hmm.
In middle.
Rule
of the-
68A.
68A,
Yes,
yes, yes, Your Lordship.
SBI provides that where pending authority finds that an officer has been fully exonerated. No, where is that? This is different provision.
Lordship, because they are at the end of the day, Your Lordship, if it is found that the suspension is not justified, Your Lordship,
Hmm.
the full pay will be paid to the employees, Your Lordship. And this is given only for that purpose, Your Lordship, as because if their suspension has been revoked and they are sent back to their job, Your Lordship, they will have the access to.
No,
the
that's a
compensation.
different thing, but thing is, that issue is that, now, I mean, there is a settled law that,
Lordship.
that suspension has to be reviewed. You haven't done the review. You have done the review after the date,
Expiry of the 90
after the scheduled date.
Lordship.
Now, whether you can justify that on the face of this case, cases. That is the issue. Now, your rule doesn't have anything else.
And it's followed in the IA, my lord. One IA is there on the next, my lord. IA is.
No, what have you annexed?
This rule, my lord, they are also, my lord, bound to, my lord, review within.
Where?
My lord, in the IA, my lord.
Hmm. IA number?
3761.
IA number?
IA number, my lord, 3761.
3761, yes.
Page 16, annexure B, and relevant portion, my lord,
Page,
page, my lord, 16,
page
annexure B.
16.
And there, my lord, relevant portion, my lord, page 17.
What does it say?
But, in the middle, my lord, periodical review of the cases of suspension. I am
Hmm.
referring, my lord, back to refer, my lord, 3.2.
Hmm.
A review of the cases at quarterly interval shall be made. And though, my lord, from the another High Court, my lord, I have submitted another judgment of the High Court also, my lord, page 18, my lord.
Page 18.
Yes, my lord. This is a Karnataka High Court, my lord,
Hmm.
State Bank of India, my lord. The relevant portion, my lord, paragraph
So here also party is State Bank only,
statement,
the similar case.
same
Ajay Kumar Chaudhary has been referred to.
refer.
In that case, your lordship, in Ajay Kumar Chaudhary judgment. Ajay Kumar Chaudhary, your lordship, in this judgment, paragraph number 14, your lordship.
Mhm. Ajay Kumar Chaudhary,
Lordship.
what is different?
Your lordship, then liberty may be granted to the bank, your lordship, to transfer the petitioners to some other branch, your lordship. In paragraph, if I may read, your lordship,
Paragraph
paragraph number 14, your lordship.
14.
Yes, your lordship. If I may read, your lordship.
One second, one second. Yes.
We therefore direct that the currency of a suspension order should not extend beyond 3 months if within this period the memorandum of charges charge sheet is not served on the delinquent officer employee. If the memorandum of charges charge sheet is served, a reasoned order must be passed for the extension of the suspension.
Hmm.
As in the case in the hand, the government is free to transfer the concerned person to any department in any of its offices within or outside the state so as to sever any local or personal contact that he may have and which he may misuse for obstructing the investigation against him.
Have you stated all these things in the affidavit?
In affidavit, we have not
Yes,
stated.
but I have no objection in that as well as other.
You haven't stated.
Not stated, your lordship.
What is your submission on that? That he is, these are all digital
Yes,
records?
your lordship, the
And
transac-
if he's, I mean, if his suspension is
Revoked.
revoked and he's posted in the same place, then he may tamper.
he may have the access to the.
He will have the access, then he may tamper it. That is your
That is my
concern.
lordship. And also the subsequent paragraph, your lordship.
Hmm.
So far, the facts of the present case are concerned.
Hmm.
The appellant has now been served with a charge sheet. And
Hmm.
therefore, these directions may not be relevant to him any longer regarding the revocation of suspension after the expiry of 90 days, your lordship. Here also, your lordship, the charge sheet has already been served and the disciplinary proceeding is going on, your lordship. So he may take part in the disciplinary proceeding and at any point of time, this is when a principle of natural justice is violated, he may challenge the same before this honorable court.
So you have been already charged.
Charge sheet, my lord, after my lord, the 3 months.
Correct. Now this is charge sheet has been filed. So, I mean, Ajay Chaudhary may not be applicable to you.
Obviously, my lord, that charge sheet was submitted, my lord, in time, my lord. It was held that, my lord, if not submitted in time, my lord, then, my lord, the
Well,
that may be revoked, my lord. And my lord, I have submitted this judgment of the, my lord, Karnataka High Court. It was also, my lord, thereafter, my lord. And our High Court, another judgment, my lord, I have also submitted. Charge sheet was submitted after, my lord, the 3 months, my lord. This is, my lord, read petition, my lord, 754/2025. The Ajay Chaudhary, my lord, it is
Yeah, Ajay Chaudhary, I mean, where, charge sheet is not filed in time.
Not subsequent, your lordship.
Who
after the
said that
expiry.
this is filed in time? Why are you making this kind of stuff?
It was, my lord, in the, my lord,
It was in Ajay Chaudhary also, after 3 months, fasting extension, there was another extension, then it was charge sheet was filed. Charge sheet was not filed in time. But when the charge sheet was filed, the Supreme Court has said that once the charge sheet is filed now, this direction may not be relevant to him.
in, my lord, I have submitted one judgment, my lord.
If charge sheet would not have been filed, then it would have been a different thing. But once the charge sheet has been filed, you may not be covered by Ajay Chaudhary. That's what I'm saying. Where is the Karnataka judgment?
Karnataka judgment, my lord, page, my lord, in the IA, my lord,
Page 18.
page 18.
Which para?
It is, my lord, regarding suspension, regarding, my lord, charge sheet, my lord, our High Court order, my lord. Kindly look, my lord, WPC 574/2025.
See, now you read the Ajay Chaudhary thing. Ajay Chaudhary has little bit of different issues. I mean, see, here, now you have been filed, given a charge sheet. Now you can always participate with the disciplinary proceeding. So where is the question of like now revoking it? Because it has been already, I mean, you have been charged with that and your, this thing has been reviewed now.
But
Already.
Not to just have a look, my lord, this judgment, my lord.
Correct.
our High Court.
Just give it to me.
But I've given, my lord.
Which paragraph?
Paragraph, my lord,
Which case?
WPC, my lord, 754/2025.
Yes.
Is referring the Judge Chaudhary, my lord, paragraph 9. my lord.
7, paragraph 7 and 9. 7, you come to 7. 7, they have quoted this is correct.
They may transfer, my lord, as it is always right is there, my lord. And in this order also, my lord, liberty is given to the respondent to transfer the petitioner, my lord, if necessary. Paragraph 9. my lord.
In your case, review has been done already
Review, my lord, after 3 months.
after 3 months.
And in this case also, my lord, charge sheet was submitted after 3 months. And liberty was granted for the last 3 lines, my lord, the state respondent are given the liberty to transfer the petitioner to any of its other offices so that the petitioner is not able to interfere with the departmental proceeding that may be initiated against the petitioner. Only to allow to him, my lord, the safely to work, my lord. His public service and interest is, my lord, affected. If longer, my lord, time is put a person in the suspension. This is the concept. There are, my lord, various posters, my lord, where, my lord, the executive, my lord, and administrative works are not being handled by the officers. According to them, my lord, they will manage the petition. Otherwise, my lord, practically, my lord, he is getting salary without work.
The para 15 of Ajay Chaudhary gives a different perspective. You read para 15?
So far as the facts of the present case are concerned, the applicant has now been served with the charge sheet. And therefore, this direction may not be relevant to him any longer. However, if the applicant is so advised, he may challenge his continued suspension in any manner known to law. And his action is of the respondent's will be subject to detail. It was liberty is given, my lord,
Hmm?
but analyzing the, my lord, law, my lord, liberty is given, my lord, if.
No, you can challenge your suspension order by any means, but not by this means. That's what it has been stated. Once the charge sheet is filed. See, charge sheet is filed. In other cases, the cases that you have referred, their charge sheets were not filed. But one case,
After, my lord, laying down the, my lord, law, it was provided, my lord, if anything is beyond the law, my lord, there is, my lord, give a challenge.
and the case, this one you have given, that 754, here actually charge sheet was given, charge sheet was filed, but no review was done, extending the suspension.
Regarding review, my lord, this is the judgment, my lord. I have another judgment given, my lord, 107.
No, that's
In both the cases, my lord, Ajay Chaudhary referred, my lord, and interfered, my lord. Page 1074 regarding, my lord, review was not done, my lord, for suspension, my lord. And this one, my lord.
here you have review, charge sheet has been filed, review has been done, but beyond 3 months. That's the case.
And this one, my lord, 754, my lord, review was done, my lord, the charge sheet was submitted after 3 months, therefore interfered.
No, 754 charge memorandum of charge was served to the petitioner
Yes, my lord, after, my lord.
after 3 months, but no review was done. The difference is that no review was done, but in your case, review has also been done. And
Review done, my lord, after 3 months.
correct, I mean, here the no review was done at that point of time.
Your lordship, in
After 3 months.
754 2025, your lordship,
Hmm.
paragraph number 9, Here it is written that, your lordship, the charge sheet has not been furnished, your lordship.
Where?
Paragraph number 9,
Which,
754.
which case?
754 2025. Read petition.
7?
54
Uh-huh.
2025,
Hmm.
paragraph number 19, paragraph number 9, sorry. Your lordship. In view of the decisions of the Supreme Court and this court, the suspension of the petitioner could not have been continued beyond 3 months period to be continued with effect from so and so. As the memorandum of charge had not been served upon the petitioner within the said period of 3 months and neither had any review for.
No, that's what I said.
That's it.
Memorandum charge sheet was not given in 3 months
That's it.
and review was also not done. But in this case, the charge sheet has been given
The review was done.
after 3 months, of course, and review was done.
Opposition is, even my lord, I have, my lord, in one case, my lord, both is not.
No,
done.
you tell me that what is the meaning of section, paragraph 15?
15, my lord.
15 of Ajay Chaudhary.
My lord, here, my lord, laying down the law, my lord, it was liberties granted to the petitioner. That
No, 15 is different.
Ajay Chaudhary.
Ajay Chaudhary 15 says,
Once the charge sheet. is-
so far as the facts are concerned, appellant has now been served with a charge sheet, right?
That's all.
And therefore, these directions may not be relevant to him any longer. However, if the appellant is so advised, he may challenge his continued suspension in any manner
Yes,
known to law.
yes.
And this action of the respondents will be subject to judicial review.
Therefore, my lord, my humble understanding is that, my lord, here, my lord, laying down the law, my lord, in the Ajay Chaudhary. Subsequently, my lord, this liberty is given, my lord, then now if, my lord, suspension is any manner, it is illegal one. Like that case, my lord, it is done after 3 months, my lord. It is, liberty is given to him to challenge this.
Correct.
Therefore, my lord, Ajay Chaudhary is, my lord, consistently.
No,
followed.
in your case also, charge sheet has been filed.
I'll mark.
The review has been done. Correct,
After 3
but
months.
it is after 3 months.
Okay.
Now, the Supreme Court is saying if charge sheet has been given and review has been done, you participate in the disciplinary proceeding and challenge the order of your suspension by any other means if it is allowed under the law.
One thing, my lord, I may be allowed to, my lord, thoroughly go to the Ajay Chaudhary, my lord, there is, tomorrow, my lord, matter may come up, my lord,
No, I mean, we have heard you. I mean, we'll decide this, we'll see this.
Because, well, otherwise, my lord, on this ground, my lord, I have placed, my lord, prima facie two judgment before your lordship. One is, my lord, suspension was not reviewed within 3 months, my lord, interfered with. And another judgment, my lord, charge sheet was also not submitted within time, my lord. Then I have another judgment also, my lord, recently. It is
No, these cases are known to us.
Yes, my lord.
We know.
It is, my lord, case name is, my lord, Dipayan Pal, my lord. Recently it was disposed of, my lord, on court number 9, my lord. Where, my lord, charge sheet and, my lord, charge sheet was not submitted and, my lord, because and review all are, my lord, done after, my lord, 3 months, my lord, interfered with. Dipayan Pal, my lord, WBC number, my lord, I can furnish, my lord. Only thing, my lord, there will not be, my lord.
One second.
Double five, double seven. WBC.
So, I mean, you clarify this point. We'll fix it on, fix it day after tomorrow
My lord.
or 6th. 6th we'll fix. Heard Mr. E.M. Borguya, the learned counsel. You also come prepared with this. M. Borguya, the learned counsel appearing for the petitioner, also heard Mr.
H. Buragohain, lordship.
A.
H. Buragohain.
H. Buragohain, the learned standing counsel.
Lordship, panel advocate. SBI.
The learned counsel appearing for the SBI. On the prayer of the counsel appearing for the petitioner, let the matter be fixed on 6th.
Obliged. Item 10 also similar matter.
Same, together one,
Same matter,
same.
Two petitioners.
both the matters to be listed.
Keep them.
That matter that we heard, is anybody there?
Make these a lordship.
Yes, I mean, see, he's submitting that this is a covered matter.
Lordship, I have two submissions to make.
Mm.
Lordship, firstly, the writ petition is not maintainable because Lordship, all the speaking orders are from 6 different districts, Lordship,
Hmm.
which they've accumulated in one writ petition.
Speaking orders are from 6 different districts.
Yes, Lordship.
Hmm.
No, Lordship, all the orders are
How many
issued by
people
the
are there?
Director of Secondary Education on 4th of February 2021, but
Mhm.
Lordship from 6 different districts, Lordship.
Hmm.
So, Lordship, the petitioners ought to have made 6 different writ petitions, Lordship, in this regard.
But they have the same grievance.
Same grievance, sir. That's my first submission. It's coming to the second, Lordship. I've gone through the
What
Yeah.
is what is your second submission?
Lordship, I've gone through this orders cover case which they've named, Lordship. Lordship, it is covered, but Lordship, review will be filed, Lordship, in this regard. Lordship, for non-teaching staff, challenging the Mohor Ali Sheikh,
The
Lordship.
review for what?
Mohor Ali Sheikh judgment, Lordship.
No. Now you tell me one thing. See, he has submitted 2 cases, case laws.
Lordship.
Okay, by this court, by Guwahati High Court. So, these 2 cases cover his cases or not?
Lordship, it is covered at
Hmm.
present, but Lordship will file the review within 10 days, Lordship.
You have filed a
No,
review.
Lord, we are going to, it's on the process of,
sir.
Lordship, it is
It-
ready, Lordship, we are going to press, it's on the process, Lordship. Lordship may keep this matter pending till the outcome of the review.
No, you have not filed a review as yet.
No, Lordship, but it is on the process, Lordship will file it within, Lordship, 1 week or 10 days, Lordship. In challenging Mohor Ali Sheikh and others, reported in 2020.
So you, I mean, you were relying to Mohar Ali what?
Lordship,
But
that's
as
the
part-
core judgment, Lordship.
Lord, on the basis of Mohor Ali judgment.
On the basis of moral judgment only, all judgments have been passed, right?
Yes,
Hmm.
there is no stay order, my lord. One review also pending, my lord. Review petition number 15 of 2025. But there is, this honorable court has already directed to file representations. And upon verification, if they are covered, then this judgment will be applicable. Paragraph 9, in view of above, this court is inclined to dispose of the petition by directing the petitioner hearing to file individual representation. And another judgment also, in doing so, the respondent authorities would be at liberty to make necessary verification as may be required. So, instead of keeping this matter, my lord, pending, that should may pass appropriate order.
No, I mean, see, this will not serve a purpose. I mean, if I pass any order, they are filing review.
They have not yet filed as part.
Lordship will file it, Lordship, on this, so, for non-teaching staff.
They
Lordship,
have not filed review. One day they will file review, notice will be issued, then all the petitioners. It will be paper publication, numbers of. Not distinct. 2 years, 3 years.
You come with your proper instructions,
Lordship.
we'll fix it day after tomorrow.
Lordship,
Day after tomorrow, come up with your proper instructions.
Lordship.
of What is happening there?
Lordship, the
I
current.
mean, if you are not filing the review, then obviously like, he has a right to get an order
Lordship.
from this court.
Lordship.
Heard Mr. N. Sharma, the learned counsel appearing for the petitioners. Also heard Mr. P.
R. Borua.
R. Borua,
For response,
Um,
3 to 10.
for respondent number
3 to 10, Lordship.
3 to 10. 3 to 10. On the prayer of Mr. P. R. Borua, let the matter be fixed after day after tomorrow. Fixed after day after
Lordship.
tomorrow. Fixed day after tomorrow for procuring the proper instructions in the matter.
The submission may be recorded. My case is covered by 2 judgments. That
No
may be-
submissions, I mean, fourth, we are taking it only. Fourth, we are taking it. Fourth, if there is no proper instructions coming, if there is no review, then we'll see.
There may appear, my lord.
Sorry?
Some other council may appear, then they will not know.
No, that is, I mean, that should not be an issue. We'll just see what exactly happening,
If
because
review is not filed-
suddenly come, huh?
If review is not filed, that this case is covered.
Then we'll consider it. That's what I'm saying. If review is not filed, if there is no proper instructions, then we'll consider this case. Only one day. 1 day has been given to us. Fine. Only. बस है ना? नहीं? नहीं, बोला था, okay.
Item number 12, next item. This matter may take come out.
No, I mean, today not possible.
Not possible. Any other date, my lord.
The daily date shall be given.
Fine.
Similar 15 item.
Sorry,
Item number 15, your lordship,
15.
15.
He'll give you a date.
Day after tomorrow or next day.
Day after tomorrow, this week it will be
Many,
difficult.
your lordship has fixed many cases. Day after
Yeah,
tomorrow.
yes.
Let it come on Thursday, your lordship.
Okay, give him Thursday, next week Thursday.
This week Thursday.
This week Thursday will be difficult.
Friday.
Friday.
Because I have to take a first step, your lordship, at new address.
Okay, Friday,
Unless your lordship
Friday.
Yeah, item number 60, no, no. Next week. Next week.
Okay, next week, Tuesday.
Awesome.